Here, my phone number. Welcome everyone. How's everyone doing? If this is your first time tuning in, definitely comment. Let me know where you're tuning in from. I got some news for you guys today. Okay, let me pin this right here. Okay, good morning, good morning, good morning. This is your first time, welcome. My name is Aisha Chidole. I'm an immigration attorney. I practice in Atlanta, Georgia, but I represent clients in all 50 states with their family immigration matter. So we handle marriage-based cases, parents filing for children, children filing for parents, fiance visas, consular processing generally. We also handle VAWA cases, chief for trafficking cases, and U visas. We also handle removal or deportation cases and some detention cases to get clients out on bond. Our numbers here are 678-325-1037. Or you can also call 678-233-2170. So let's get right into it. I told you guys, you guys always ask me this question, update. I've told you all that once we have some kind of viable updates, that I will always let you guys know, because to me, there's no point giving false hope or false anxiety, whichever opposite or extreme. I just like to bring the correct immigration information. I'm not a newscaster, so I don't need to do like news. I just like to give the information that applies to, what it is that I'm talking about and what's going on, not just because I want to do clickbait. Anyway, so yesterday, there was a publication, or basically the judge ruled. So there was a lawsuit that was filed by I can't remember what his name is, D'Souza or Demora. I can't remember the person's name right now. Filed a lawsuit against basically the Department of State on the 75 country pause. If this is your first time hearing it, the 75 country pause is a pause that was passed for 75 countries based on public charge. Basically, what do they mean by public charge? They're basically saying that these people are likely to get some sort of government benefit or need governmental assistance when they come into the United States. So basically, they just stopped processing those cases outside the United States. Remember, guys, this 75 country pause I'm specifically speaking about is for people outside of the United States. It has nothing to do with anyone in the United States. So I want to make sure we don't confuse that. Basically, the judge basically passed a ruling yesterday saying that this is unlawful. And basically, what the Secretary of State has done is try to circumvent what INA just means, immigration rule, and what Congress intended. Where people should not ban, pause an entire country, saying that everybody in that country is a public charge. You have to make the decision on an individual basis, which is what it's always been in any case for that matter. So the judge basically ordered them to process that applicant's case as a normal processing. So meaning if it is time for decision, make a decision, whether you're approving them or you're not approving them. So why is this relevant? So even though this is just that one case, there is a class action pending, Clinic versus Rubio, pending right now for the same thing, which if that one is rendered unlawful, they will most likely ask them to start processing this case immediately. So similar to what happened here in the United States, where there was the pause on adjudicating cases from 39 countries, which, as you guys know, now have started being processed. So that is what we are expecting to see, hopefully, with the Clinic versus Rubio lawsuit. So why is all of this relevant to you guys, or especially those of you who want to file for consular processing? I read some of what y'all, write, or some of what people who consult with me have said, or, clients I've spoken to, who want to know whether or not they should be applying for consular processing because they don't know when this is going to be over. Let me tell you something. If you or any of you were in the immigration circuit during the first administration where there was the ban or whatever it is, you will know the kind of backlog that happened once that ban was lifted. And that is why myself and most other attorneys are saying to you guys, because they're allowing you to process, you need to process your case to the very end. If the only thing that is keeping them from making a decision on your case, let it just be that there's a pause of the ban, so that once the ban is lifted, you're one of the first people prioritized for them to make a decision on your case. Because for those of you who will be planning to apply once this pause is lifted, you better get in line, because it's going to take you several years. When that ban was lifted, it was taking people 3 to 4 years, right, to do it. Now, we've had clients, certainly, that have gone through the process. They've prepared everything. They've given their medical to the consulate. They've attended the interviews. Whatever it is that the consulate has asked them for, they've provided that. And all that is left is literally to have this pause lifted, or the ban, depending on what country you're from, with the ability to email them, with the subject line for them to do it. Because at that point, there's nothing else to adjudicate, because basically that is the only thing stopping them from approving those cases. So again, this is why we say to y'all, when y'all wait and, oh, I'll do this later, I'll do that later, whatever it is, listen, nobody is God, meaning nobody can predict time, nobody can predict change, or whatever it is. If there is viability, if the Department of State is saying continue to apply for this process, which they literally say on their website, go on there, go to travel.state and tell what you got, continue adjudicating the process till the end, you need to move. And I suspect that this pause they even have outside of the lawsuit, and this part is just me suspecting, so this is not law, this is not nothing, this is just me in my head saying, I suspect that since they are coming up with this new public charge process for here in the United States with your I-485 in September, I suspect that would also allow them to create something similar for consular processing, so that maybe they can start processing those cases. I don't know, this is just a suspicion, but that said, based on this judge ruling that this is unlawful, and pointing out what the INA and the Congress intended, I feel confident that this is probably going to be the same outcome in the class action. And if that class action, stops not USCIS, but like Department of Justice, I said Department of Justice, Department of State, from having this pause, then they will start processing cases. So that was the update I wanted to give about that. I'm going to go through and take questions. So someone says, I'm just waiting for the ban to be lifted. They didn't ask for anything else. They just told us there's a ban and they will keep in contact. Yes, so exactly. You said I had a consultation, or I made a consultation with you. Exactly. So if you've gone through the whole process, you've gone through the interview, and that's all you're waiting for, I would suggest, you just get to that point. One thing I will also note is I wouldn't even wait for them to keep in contact with you. If USCIS, I keep saying USCIS, I'm so used to dealing in America right now. So if the pause is lifted or the ban is lifted, I say be proactive in your outreach. Be proactive in your outreach and letting them know what stage you've gotten with your case, and being proactive with it. If you have had your interview at the consulate and there are things or documentation they need from you, I would suggest that you get that documentation, right? And make sure that your file is basically complete, meaning they have everything to approve your case, and all you're essentially waiting for is for this pause to be lifted. All right, guys? Okay, so let me take some questions. Somebody's asking, can you file an I-751 if your spouse refuses to sign the petition? Yes, you can file an I-751 based on a waiver. First of all, what is an I-751? An I-751 basically is the application you file to remove the conditions on your 2-year green card. People typically get a 2-year green card if at the time their green card is approved, they've been married for less than 2 years. And then after you've had that green card for 2 years, you need to file for what we call removal of condition, which is Form I-751 with your spouse. So usually it's a joint application or joint form that you file. Now, do all marriages work? No. If that is you and your marriage didn't end up working out, or your spouse refuses to sign, you want to consider if you're eligible for any of the other waivers. So the other waivers that might be available to you is a waiver based on divorce. If you and your spouse get divorced, you can file a waiver based on that. If your spouse becomes deceased or passes away, you can file a waiver based on that. If you have experienced extreme cruelty or abuse by your spouse, you can file a waiver based on that. If you will experience or have experienced extreme hardship, you can file a waiver based on that. Please note that the extreme hardship cannot be something that occurred or was in existence prior to you getting a green card. The hardship has to have begun after you became a 2-year green card holder. So those would be the basis in which you would file it. Okay. Is somebody on a traveling parole, can they attend a graduation in Canada? Do I need a visa to visit Canada? The first question you should be asking yourself is, what country are you from? Advanced parole is only permission to re-enter the United States. It doesn't give you permission to go to a random country. So in order for you to go to a random country, you first of all have to find out, what country are you from? I am going to take a guess based on your name, Kende Babalola, that you're Nigerian. As a Nigerian, you do not have the rights to be in Canada without a visa. So in order for you to go to a graduation in Canada, you actually need to apply for a visa. And if you're approved for the visa and there are no issues potentially, because I don't know what your case is or your immigration history is, then that would be something you would consider. But again, advanced parole is not a visa to enter another country. Advanced parole allows you to come back into the United States. So make sure you're mindful of that. Okay? And also, because I know sometimes, and then also for some green card holders, if you're a 2-year green card holder, you can't go into Mexico without a visa the way a 10-year green card holder can. So that's just a side note, because I know that some people have asked that question before. Will a warning ticket from the police because of a taillight affect a green card plus extension letter holder during re-entry into the United States? It shouldn't without more, but a warning ticket should not. If you forget to include a citation for a traffic violation for a stop sign, which a lawyer pleaded on your behalf and was brought down for parking ticket and fined $140 on your I-485, I guess you're asking what's going to happen. You have the opportunity to amend that. You can amend that or bring that ticket to your interview. That's number one. The second opportunity you have is if you have your USCIS online account, you can log in and go and upload it in the document section or unsolicited evidence section as well, right? With USCIS, really, when you forget, when you omit certain things like that, the key is you want to correct those things before it is brought to your attention so that it doesn't appear you're trying to cover up something or lie about something, but you always have the chance to amend and correct things, okay? How long does CR1 take? My priority date was December 2025. Unfortunately, I can't answer the question because I don't know what country you're from, or anything like that. Hello, Attorney, you're the best. I've been waiting 15 months for my adjustment of status since my vow was approved. I submitted everything together in 2021. How long do you think? Yes, it is very annoying, as you guys know, because of a lot of the fraud and politicization and just everything going on with VAWA. VAWA cases are taking longer than normal because clients are being interviewed, whereas before, it's like a 20% interviewed, 80% if you're approved, then you can move on, so I suspect that because of the interviews that they're doing, these cases are going to take longer and they're going to, have to do a lot of vetting, but in good news, I had posted two VAWA approvals, two VAWA green card approvals last week. Was it last week? Yeah, last week. One of them, theirs was submitted in 2021 as well, and they had gotten their VAWA approval. They had their interview while I was out of the country. Actually, they had their interview in like late July, and they got their approval. And the other one, the other one actually had their interview earlier, like in April, but they just got their approval. So it's. I know that it's very frustrating. It is frustrating for me, and I'm sure many other attorneys as well, just because you want to move on. Because also, you know, who wants to be holding on to these cases and constantly updates. You know, what's going on, what's going on. So just if you try to, you know, exercise more patience, hopefully they'll make a decision, or I mean, schedule for an interview pretty soon. Okay. How do I know if my I-130 has been approved? You should get a letter of approval. That's usually how you know. If you have access to a USCIS online account, you can also put in check there. And then the third option is you can go to USCIS case tracker and put in your receipt number, and sometimes that will be updated as well. So those are places you can check. Some of those questions are repetitive. Dami says, can you attend an upcoming interview without your spouse because your spouse is in jail for an I-751? Yes, you can. However, the officers have, you know, the discretion to continue to interview or not continue to interview. One of the things that the officers are going to be looking at is how strong is your good faith evidence, you know, and all of that for them to make a decision on the case. Okay. I'm trying to get a divorce, but my spouse isn't allowing it. I've already filed for a waiver to get my conditions removed. Is getting a divorce? Will it impact my case? So first of all, your husband or your spouse? Did you say your husband? Your spouse does not have the right or the authority to tell you what they will allow or not allow as it relates to termination of your marriage. If you actually did file for divorce, you know, the courts usually would have a timeline or a deadline. If they don't respond to the complaint, where you will be granted default judgment, you know, as a matter of law and right, because they didn't respond. So whether your spouse wants to sign it or not, you know, or respond or not contest, you know, that shouldn't stop you if that is a choice that you've chosen to make for yourself. If you are filing for removal of conditions, you said you already filed for a waiver, so I don't know what waiver you filed for. But if you file for a waiver based on divorce, they will not be able to make a decision on divorce without the divorce decree. So you want to definitely get that finalized. If your waiver is based on something else, extreme hardship or abuse, then if you get divorced, you can also add divorce. So meaning you can also amend your waiver to add divorce as part of the basis for it. Okay. What happens if USCIS shows up at your place and you're not around? Every officer is different. So that's usually the USCIS fraud unit. If they show up to your place, if you're not around, they usually can call you and find out where you are, whether you can come back home or whether they can come meet you where you are. Sometimes the people are at work, they'll say, can we come meet you at work? So it's just different, you know. It's up to whichever officers come in however they want it. There's no standard of what they do. Okay. From a 39 country I-485 interview. It's been 2 weeks ago. No decision yet. Please advise. There is nothing to advise. You just had your interview 2 weeks ago. 2 weeks ago. That's not a long time. What can you do if USCIS issues you two receipt numbers for I-360, I-485, including issuing 2 cases? Sometimes, guys, I don't understand what you are writing, and only 1 case was filed. I'm not sure I understand what you're asking. You're saying they gave you 2 receipt notices, 2 different receipt notices? Is that what you're saying? 2 case numbers for PF? Like, I don't understand what you're saying. Does the waiver you mentioned earlier apply to individuals outside the United States? with their spouses in the U.S. or strictly for individuals who are in the U.S. while married or divorced. If you're talking about the I-751 waiver, I-751 waiver means that you have a green card. It doesn't matter where you are. If you have a green card, that's what it is. And in order to have a green card, if you're outside the United States, you have to enter into the United States on a spousal visa. I'm filing for my mom who lives in Nigeria since December of 2025. Is a pause affecting this? So in Nigeria, there is a pause as well as a ban. So you've got two things that you have to cross over the hump. Even if they rendered the pause unlawful, there also is a ban. So what that means is that if you file in December 2025, I'm assuming you file the I-130. Once the I-130 is approved, make sure you go through the National Visa Center process to fill out her DS-260, put in your financial affidavit of support, whatever it is that they ask you. When she does get documentary qualified, then it moves over to the consulate. The first thing that happens is that they're going to send an email to the email on file requesting for a document review interview. This interview is just to review the documents, so they're not asking questions about your relationship. It's just bringing together all the packets and all the things that were submitted at NVC. And then if there's anything that's missing, they will let them know what's missing and tell them to upload it on CEAC or bring it to the interview depending on what it is. And then they'll schedule the second interview. The second interview is usually, so actually no, when they schedule the interview, they actually schedule the main interview. And then after the main interview is scheduled, they will schedule a document review interview, but the document review interview will always come before the main interview. So once you've uploaded those things, you attend the main interview. If she attends the interview and everything is good, they'll just give her a paper letting her know that they're prohibited from approving her case right now because of the presidential proclamation, which is based on the ban and the pause. However, if it is lifted, this is the email to reach out to us and use this as a subject. So that's what it's looking like in Nigerian embassy and most embassies. When is a good time to reach you? When you schedule a consultation. I am in consults or at USCIS most days, so you don't just call on the phone and I will pick up because I'm respecting other people's time who have booked a consultation. So if you'd like to reach me, please schedule a consultation. My number is pinned right here on Instagram. It's also on the ticker on Facebook, YouTube, and this is my profile. Okay. If you've been married for a year to an American citizen and your TPS ended, what can I do? You can certainly file for adjustment of status if you're eligible. If you're eligible for adjustment of status, you should file for adjustment of status. I mean, you heard, DHS Secretary Mullen saying that, if your TPS is terminated and you have another ability to, adjust, follow that process. Happy to speak with you and see if you're eligible for adjustment of status. If you're eligible for adjustment of status, you should definitely do that. How soon after your biometrics for N400 are you called for an interview? Unfortunately, I don't have an approximate time frame. This August makes 2 years since I filed for removal of conditions. Is it possible I would receive my green card soon? I'm in New York. Removal of conditions are taking about 3 years, 2 to 3 years. So if you are still pending, one of the best things I would recommend to you is if you are eligible for U.S. citizenship, file for U.S. citizenship. So that will just kind of shorten the time a little bit. What will happen is they will schedule you for an interview for both citizenship and the 751. If they approve the 751 and they approve the citizenship, they'll bypass the 10-year green card and give you citizenship. Okay? All right, guys, I got to jump off. But again, schedule your consults. File those cases if you're eligible. If it is a process that's not barred, that allows you to continue the process, get in line. Don't be one of those people that's filing in 2028 and then you're not going to get anything till like 2032. Again, our number here is 678-325 1037. All right, guys, have a good day.